Hello, party people, and welcome to the final episode of this season of Law and Candor, the podcast wholly devoted to pursuing the legal technology revolution. I am Bill. I am here with Rob as always, and we are thrilled to have you for this last episode. Before we kick off the interview with Thora Johnson, Thora is a partner in the Cyber Privacy and Data Innovation Group at Orrick. It's a really interesting discussion. I think you're going to love it. First, we have to bring to you the favorite portion of the program. We call it
Sightings of Radical Brilliance.
This, of course, is a portion of the program when we go through the latest news of noteworthy innovation and acts of sheer genius. And for our last episode, we wanted to keep it light. If you remember the first episode, we talked about technology and murder. Today, we're going to discuss something a little bit more light. It's an article in the New Yorker, and it's entitled, Appreciating the Poetic Misunderstanding of AI Art. Roberto.
Yes. And again, consistent with our theme of really trying to step up our game a little bit. We've had Harvard Business Review as one of our articles. Now we are moving to the New Yorker. I don't know, Bill. Next season, who knows what we'll be talking about. But this is an interesting one. Kind of imagine a technology, and this is kind of run through a Twitter account, but you can describe something to it like, hey, what would an Art Deco Buddhist temple look like? And then in the background, there are two different algorithms that will sort of compete against each other to come up with an image that best captures whatever that text was that you fed it. And like a lot of, AI, sometimes it creates a really interesting kind of right on image. And then other times it just goes horribly, horribly wrong. And I love that this just kind of captures that nuance of AI and when we try to apply it to different situations like this. And I'll just give you one more example. One of the examples is somebody had asked to see Elon Musk experiencing pain. And what the algorithm yielded was this kind of grotesque collage of, grimacing faces and Tesla chargers. Again, not exactly on target, but
yeah, it's quite the mashup. So this Twitter handle is actually run by a 21-year-old student at Northwestern, and it's not a bot. There's actually a person behind it, but people are interacting with it. The Twitter file. I just logged onto it. There's actually almost 50,000 followers for this thing and for this particular Twitter account. And it's there are people like Lady Liberty just had a +1, so they did Young Sheldon and Lady Liberty. I don't know. It's a strange account. It's really funny. But this student at Northwestern is essentially, saying that they're getting requests all the time. And the quote is, most of the requests are crap. It's interesting to see which ones they choose to do, because the ones on the Twitter handle that I'm looking at right now are, love and death. And it's just an AI drawing of a bunch of hearts and skulls. So some of them are really interesting to see how it puts it together. And like you said, it's a competition between these two algorithms and how they put it together. And some of the images are beautiful, and some of them are just strange and odd, and some of them are super disturbing, like the one about Elon Musk that you mentioned.
Yeah, again, pretty fascinating technology. There's another part where it talks about that there was a system that that was created that it could take an image and then automatically produce a description of it in text. And again, because the AI kind of like has no filter, it would just create these horrifying, biased and cruel captions, something that, hopefully would never come out of a human's mouth. And then sometimes, of course, it can spit out something that's kind of beautiful. So again.
Yeah, I'm going to put in a request for like Bill Mariano and Law and Candor, and just see if they can come up with an image for that, and then we'll post it on the website. But yeah, it's an interesting article. Again, I found it interesting because I thought this is what happens when a technology gets so prolific that everyone can get their hands on it. You're going to see some innovative stuff. You're going to see some ridiculous stuff. You're going to see some evil uses of it. Obviously, we've talked about that a number of times. But this is just something that's silly, lighthearted, and something that 30 years ago would never have made any sense.
Yeah, this was a great article to wrap up the season with. And now we turn to the main event. We've got a great speaker, Thora Johnson, partner in the Cyber Privacy and Data Innovation practice at Orrick. Excited to learn a lot more about wearable devices, data, and compliance, and this is going to be an amazing episode. Hello, Thora, and welcome to Law and Candor. Just, we'd love to just maybe kick things off and just hear a little bit about your background and, how did you come to specialize in cybersecurity, privacy, and healthcare?
Sure. It's great to be here today. And I'd love to share my background because it's unusual. And I'd love to say that it was methodical and planned and thoughtful, but it was much more organic and recognizing opportunity when opportunity presents itself. I started my career in the employee benefits group of my first law firm. And that's a pretty unusual track, I think, to end up doing cyber and privacy. But when I joined our employee benefits group, healthcare was becoming much more regulated. And the partners that were in my group really had the 401k retirement plans covered. I quickly ascertained that type of work was a little bit boring for me, and I was really all in on learning these new laws governing health benefits. And one of those would be privacy.
If it makes you feel any better, we've never talked to someone on this podcast that intended to be where they were. I think we've all just kind of found ourselves here, but that's great. Thanks for sharing your background.
I think that's the joy of life.
The benefits around 401k and the practice around that, it's not just boring for you. I'll throw that out there. So, when we talk about wearable devices, I'm really, when we came up with this topic and we were able to secure you as a guest, we were really excited. It's not something we've ever talked about before, but it's something that's so interesting, especially with the proliferation of all these wearable devices and all the stat that it tracks and the information it tracks on the individual user. Most people probably think about Fitbits. They probably think about the Apple Watch. But let's talk from a broader perspective about the range of different health-related devices and apps that you're seeing and what that means for privacy.
So really, there's no end in sight as to what can be tracked and what can be quantified. And you're right, it started very simple with steps, and now we see sleep and heart rate. With the pandemic, we've seen tracking. We all have those apps where we track how we're feeling in the morning and do we have a fever. And now we're seeing vaccinations being collected by apps.
DNA.
And we're seeing also as part of this pandemic, behavioral health, right? A lot of apps helping people cope with mental health challenges. And actually, there really is no end in sight. My sister just got her booster last week, and she sent me a picture from her phone. Her watch had tracked her stress levels and proved that the day of vaccination increased her stress levels and her body was working hard.
That's amazing.
So there really is no end. And then there are all kinds of connected devices, right? There are X-ray machines connected to phone apps and blood pressure cuffs and glucose monitors. It's really sky's the limit. And it's so important and critical for the way we deliver healthcare in the U.S. We have always had problems containing the cost of medical care, and putting these devices in the hands of individuals and consumers in their homes, collecting the information, maybe we will get to a point where we can actually help bend the cost curve. But we're certainly, if we never get there, we're certainly delivering healthcare in a brand new way. And the reach of healthcare, right, to rural America is there.
So, Thora, when you talk about all these different devices that exist and the different types of data they're collecting, like some of the questions that jump in my mind immediately are, that seems like it's raising compliance issues, security issues, and of course, privacy. What are the most critical issues that you're seeing and addressing?
You hit them both right on the nail on the head. First is privacy and compliance obligations. It's a very complicated field with both federal and state regulations and overlapping regulations. I mean, on the federal side, it is your alphabet soup. You have the FTC, a longtime player in the space. You have the Office for Civil Rights within the U.S. Department of Health and Human Services with primary obligations for HIPAA compliance. You have a relatively new player. You have ONC, which governs health IT and certain providers and has rules about blocking information sharing. And you have the SEC taking an active role in cybersecurity for publicly traded companies. That's on the federal level. We haven't even touched the state level.
Exactly.
Right? you wouldn't think that there'd be a void, but the states are really stepping in, and you have state AGs who are being very active in privacy and security. We have departments of insurance, to the extent you're talking about health insurance companies or producers. We've always had state data breach laws, but they didn't always get to medical care and medical information, and many more of them do today. And then we're just seeing new state laws out there that are trying to address the fact that oftentimes when you have a reportable cyber event, class action litigation quickly follows. And so a few states have now tried to incentivize companies to put in proactive cybersecurity programs by offering some relief from those class actions, whether it be in the form of a defense to punitive damages in negligence claims if they have a cybersecurity program in place. It's kind of exciting to see where those laws will go. But to your point, compliance is a huge issue. Figuring out what laws you're actually subject to, and they're all, and then there's the cybersecurity risk with the proliferation of data, with the proliferation of where that data is being collected and how it's being collected. You definitely see cyber incidences on the increase, and you see the regulators, although they're numerous, stretched in responding to the cyber risks.
Yes, so let's talk about that a little bit, because I think some of us, whether it's wearing an Apple Watch or a Fitbit, or people that sign up for 23andMe, some of them people are doing it because they want to leverage the best cutting edge technology to protect their health and be in charge of their health and get a better grasp of their health. And I think that, and also the convenience of it, right? I don't have to go to the doctor to check all these different levels. There's a convenience factor as well. That said, there's an obligation of those and attorneys and legal departments of companies that have this data and are storing this data. There's an obligation that both from a regulatory perspective and more with these more regulations popping up and more agencies taking a look at it. What are some of the technologies available and the best practices that attorneys that are that have this kind of data, whose companies are collecting this kind of data, should keep in mind and or follow?
Sure. Being proactive, right? That would be my first tip. And to the extent that you are in compliance and privacy, it's making friends with your folks in security. No longer are they two ships that pass in the night. Privacy and security are very much joined at the hip and should be joined at the hip, and scaling and growing with the privacy and security in mind. So thinking about where your data is, what you're collecting, where is it within the company, what information systems have the information, what third parties are you using, and how can you respond? How can you be transparent with your consumers about what data you're collecting and how you're using and disclosing it? And then how do you provide them with rights over their data? All of these new state laws that we see all provide some level of customer control over their data, or access rights, for example, or rights to amend the data. And you see that started with GDPR. It's certainly part of HIPAA, and now you see it in the state laws. So thinking through what you're collecting, where it is, and how you're going to provide consumers with rights to their data.
Thora, one of the things that you mentioned before were cyber breaches, and this is a topic that we've discussed a lot on the podcast. The data that are when you think of kind of like the scope of data that can get involved in a cyber breach, it's all bad, but health-related data seems particularly sensitive and bad. I mean, clearly it raises the stakes. What advice are you giving or hearing that helps people mitigate the risk of a cyber risk? And in the terrible event that it does happen, what are some best practices and how to respond?
It's a great question, and I wish I had the magic bullet there. But again, on that proactive side, it's actually conducting risk assessments on a periodic basis, looking at your infrastructure, hiring a third party that comes in and does that for you and helps you uncover what your vulnerabilities may be and then remediating them. And it's not a bad idea to switch out every few years who comes in and does that assessment for you, so you're getting fresh eyes on it. And then it's thinking about what tools you can actually supplement your program with, right? Do you have a good data loss prevention tool? And then if the unfortunate happens and you have a security incident, cool heads need to prevail. Get your assembled team together, right? Get your legal, privacy, security. And not everything is going to be a full-fledged reportable breach. It's assessing what the situation is. It's actually, first of all, is mitigating any damage, right? Control the situation. And then get your trusted advisors, both within the company and outside the company, together and work it through.
So let's pivot a little bit to the regulatory perspective on this, and specifically, there's more of a focus we're seeing around managing cyber breaches. In an ironic twist, it's not a new statute or law or rule that's being written to deal with this. It is a 12-year-old rule that has, to this point, been relatively unenforced. Is the focus of all this here. Let's talk a little bit about the FTC's recent announcement that it plans to enforce the 2009 health breach notification as a means of dealing with the 2021 problem.
Right. It's a fascinating little twist. So you're right. It's a 2009 breach notification rule. When it came out, I think that the common understanding is it was meant to get at a breach that happens outside of HIPAA, right? So just to level set here, people often think that HIPAA applies to all medical data. It doesn't. It applies only to certain medical data, in that it has to be in the hands of a covered entity or one of their vendors known as a business associate. But those covered entities are health insurance plans and providers that enter into certain billing transactions electronically. Those are the big two buckets of covered entities. And then there's all this other health data about these apps that we've been talking about that are direct to consumer. Those are not subject to HIPAA. This is where the FTC's relatively new statement that they're going to vigorously enforce their breach notification law really comes into play. So as I was saying, in 2009, I think people thought that it had a limited scope, basically to personal health records. So an individual collecting all of their health records, which is a real problem in the United States, right? You go see your primary care physician, that changes over time. You add a specialist here, you go to this hospital, you're traveling, you go to that hospital. Your records are everywhere, right? They don't follow you. So the idea of a personal health record, that you could collect all of your records and you'd have it on your app, and then you would have it with you to share as needed. That's what I think was commonly understood to be governed by the FTC rule. But with this new statement, it's much broader. They're saying health apps are a type of healthcare provider, and if they are pulling information from multiple sources, they're subject to this breach notification law. One of the sources does need to be healthcare, but it can be the individual saying, this is how I feel today, or these are my COVID symptoms of the day or lack thereof. So one source can be the individual. Another source could be pulling the calendar off the phone into the app. So relatively benign. Or it can be pulling from APIs, right? There are new rules that require, for instance, Medicare Advantage plans to share information with an individual at their request. So it could be something more sophisticated, pulling from APIs, but generally speaking, the rule is much broader. And it's now saying that if there's a breach of one of these covered apps, then there's a requirement to notify FTC within 10 business days, which is pretty darn fast. If it implicates more than 500 lives. If it's less than 500 lives, you have a little bit more time. And then there's also the notification to the media in certain circumstances, and certainly to the impacted individual.
Yeah. I mean, there's a big difference between, the resources that a health system has versus the developer of an app. That's interesting. Another thing, like of all the different legal and technology areas we talk about, like this might be the most dynamic one right now. Anything people should be sort of tracking on their radar? And one question I just have to ask, because I find this one so interesting, is what about these different genetic testing companies and apps that we keep seeing and are sending me emails all the time? Have you had any experience with those?
That's exactly what I was going to talk about as of areas that people should be keeping in mind. We're seeing not so much on the federal level, but we are seeing this proliferation of state laws that are providing protection for consumers, for genetic testing companies, and also companies collecting biometric data. and it is very interesting because you do need to carefully watch. Are the companies already subject to HIPAA, in which case there may be exemptions and you rely on the HIPAA compliance. But if they're outside, if there's direct to consumers, definitely seeing these new state laws. California, not surprisingly, is one of them. And the requirement of transparency and consent from the individual. That is definitely a trend. Genetic information, biometric information. I mean, genetic information is so sensitive for all those obvious reasons. So not surprising to see more regulation there. And then AI in healthcare, machine learning. I think we're going to see more regulation around the use of AI in healthcare. Transparency there. Making sure there's a right to question the deliverable of the AI. We're seeing a little bit of that under the GDPR. I think that will come here.
So looking to the future then, you talked about how there's really no end in sight for the type of information that these apps and technologies can track. Let's talk about where do you think it's going to evolve to, especially the regulation around them?
I think we're left with a patchwork for quite some time. I think that we'll see more and more state laws. I do think that they require really careful consideration about how they work with the federal regimes, such as HIPAA. I think it is a real challenge for companies that have consumers across the United States to comply with the patchwork of information and laws. And that partly goes to my comment about building with privacy and security in mind at the front end and trying to figure out what the common components of a privacy and security compliance regime look like on the privacy side, right? The example that comes to mind is building with consumer rights in mind. So I do see continued state law involvement in protection and confidentiality and privacy of medical information and transparency requirements, right? Telling the consumer, we're collecting your information and this is how we are using it. I don't think, there have been some cries again for a federal law. I think that is a long, far-reaching goal. Yeah,
God forbid the federal government gives us some sort of level, bar to set rather than 50 different bars that we have to worry about across the 50 different state laws. I do have a follow-up.
Yeah.
Let's say there is this really, really cool, charming podcast host that at one point early in the release of 23andMe, just for laughs, sent his stuff in. And now after hosting a podcast with a certain guest has regrets about that and wants to send them a note and say, hey, by the way, I would love to find out what you have about me and I want you to erase it off their system. Does that podcast host have any recourse to do that? I'm asking for a friend.
Yeah, it's always a good question. So yes, you do, or your friend has the right to say, look, I would like to withdraw my consent. And if they are subject to the CCPA, a right to request that they delete your data. So
I will tell him or her that you said so. Thank you.
And I want to say one other thing. We were talking about how this patchwork, a patchwork of state law is not unusual in healthcare. Healthcare has forever been a patchwork of state laws, right? The practice of medicine is governed by each state. So it's a continuation of that trend in health data privacy.
I was thinking about Bill's friend's question. And I wonder if, after that high-level case where, the serial killer was identified through that data, I wonder how many of those withdrawals of consent were sent to the companies in the next month.
I don't think that's why my friend is asking. However, I just want to throw that out there for the record. I think my friend was asking because this podcast might have put a spook into them. But that's the reason there.
One more spook to throw in there, though, is that in healthcare and health data, we've been talking about privacy concerns, but there's a real concern out there for treatment purposes, right? The health and well-being of the individual. And we have seen now the first lawsuit that, at least that I'm aware of, where a hospital was offline and there was a birth injury, and the lawsuit is using the fact that the hospital was having a cyber event and was offline as a basis for a tort claim for wrongful death. So,
wow,
very interesting times. Just to put it in, you know, it's not only when you're talking about health data, it's not only about privacy and security. There's also real well-being, life and death
practical
decisions.
use. Yeah. Wow.
Thora, you have been an amazing guest. This is definitely one of my favorite podcasts that we've done, and we just want to thank you so much for coming on. I'm going to try to just do a quick summary, and I know I won't do it justice, but I'll do my best. I love the observation that, you know, there really is just no end in sight to the different types of devices that are out there and are, you know, coming onto the market, the different types of data that are being collected. I thought that your comments about how, you know, this sort of triumvirate of compliance, security, and privacy issues, you know, that keep popping up and need to be addressed was great. I think the sort of dynamic environment that companies are dealing with this, with having to, you know, balance both state and not as much federal, but, you know, on the enforcement side, definitely, and hopefully at some point on the legislative side, you know, a lot of new laws, a lot of new technologies. But I think my favorite part was just the great advice that you gave, you know, about being proactive, making friends in your privacy and security groups. I think that's advice that transcends just this issue. Conducting risk assessments, hiring third parties to help, you know, and maybe even rotating those third parties out. And if you're identifying issues, you know, fix them quickly. Keep an eye, especially on biometric and other really sensitive data types. And I thought that discussion around the new old FTC rule was amazing as well. Thanks so much again for being willing to come onto the podcast. It was amazing.
My pleasure.
Yeah, Thora, thank you. And my friend thanks you as well. Can you believe it? That is a wrap on season 8 of Law and Candor. Unbelievable 8 seasons. Unbelievable this season is over. Please be sure to subscribe to Law and Candor. Unsubscribe, resubscribe. Give us the highest rating you possibly can wherever you get your podcasts. You know, if for those of you that have them, wear your Law and Candor t-shirts around town. You'll be the most popular person in your town. I guarantee you. Actually, if that's true, you have problems. Also, please follow us on Twitter @Law and Candor. Check us out, follow us, pass on the information. We love talking about this stuff. Frankly, if you have ideas for Law and Candor, we'd love to hear about it. Please tweet at us for ideas around Law and Candor. And if you have any people that you'd like to hear on Law and Candor, hit us up on Twitter @Law and Candor on Twitter. And yeah, we look forward to season 9. Thanks so much for joining, everybody.